Hi and welcome back. Attorney Steve Vonner, the business and real estate lawyer, and we are talking in this video about the statement of issues. So without further ado, let's head to the Attorney Steve real estate whiteboard. Okay, let's back this baby up. Let's get going and let's get some action here. Can we back this up? We're trying to back it up. Not working there. Okay, we're working. Technical difficulties here today. Okay, so statement of issues. This is talking about when you're applying for a license. We are talking California law here, okay? But basically when you're applying for a license, my firm handles the real estate side of the licensing, but this may also apply to teachers licensing and all sorts of vocational licensing, this, that, and the other. You're trying to get your license and you're being denied by the commissioner of either, in my case, the DRE, the Bureau of Real Estate, the California Bureau of Real Estate, formerly the Department of Real Estate for you buffs out there, and the DBO, the Department of Business Oversight in California. They're the ones that do the California Residential Mortgage Lender's License, the CFL license, which is the California Finance Lender License, and the BRE handles your real estate brokers and your real estate salesperson's license. So if you're applying for one of these, you're having some issues, these are the types of things we can help you with. But what happens basically, you're applying for these licenses. Let's start over here. You're applying for your licenses, you fill out the application, you pay the fees, you've passed your exams, and you're ready to get that license. And you fill it in, you answer all your questions honestly, especially where a lot of people get tripped up is these prior criminal disclosures. The language can be a little bit tricky, and depending on what has happened to you in your past, you may check no when it should be yes, or yes when it should be no. These things can lead you into big problems. The regulatory agencies see that as a misrepresentation. They may also see it as procuring a real estate license by fraud. So you have to be very, very careful when you're filling out these applications to get your licenses. But what happens here, you fill it out, you're getting excited, you're just waiting, you can't wait for that good news, and instead what you get is a statement of information, a statement of issues. Okay, a statement of issues. This pen's dying down, I'm going to switch colors here, but you get a statement of issues, and the statement of issues is basically a list of the grounds and the reasons why the regulatory agency wants to deny you. Again, if you're in a teacher's or this or that, you're going to get the reasons, okay? It may have to do with a prior criminal conviction. It may have to do with non-disclosure. It may be some character item that popped up somewhere, okay, about your character evidence. Your character as a person. So there's lots of different things that can pop up. But when you get this statement of information, this is their intent to deny you. This will shift the burden to you as the applicant, as the respondent, named in the statement of issue. You'll be named as the respondent, and you will have the burden of proof then to show that you're in good compliance with the statutes, that you're entitled to your real estate license, that you meet the character requirements, okay? If it's a past crime, that you have sufficiently rehabilitated yourself, okay? So these are the things, that is the intent to deny you, the statement of issues. It's going to set forth the issues, okay? I just want to note a distinction. You've probably seen some of my other videos with accusations. We handle real estate accusations. An accusation is different. This is when you already have a license and the BRE or the DBO is looking to suspend or restrict or revoke your license, okay? So the accusation is different. As we've talked about in other videos, your real estate license is a property right. It's a property right. And so when they are looking to curb your rights or take your rights or restrict your rights, they bear the burden of proof. The regulatory agency bears the burden of proof, and it's usually a clear and convincing standard of evidence. That's a very high standard. We have a video on burden of proof if you want to check that out, Vondren burden of proof, okay? But in a statement of issue, the burden will be on you. The burden will be on you to come forward with the evidence, submit the package, and show that you're the good person, you're entitled to this license, okay? Key points, 15 days. 15 days you will receive with your statement of information a notice of defense form, notice of defense. You'll have 15 days to complete that and send it in and say, I want a hearing. You can represent yourself, you can appoint a lawyer, someone to represent you. but you have 15 days. If you don't get this in 15 days, you could be deemed to have waived your right to a hearing. In other words, bye-bye, hearing gone, okay? So 15 days, and again, this is usually personally served on you, could be sent by registered mail, but you have to be served with a statement of issues, okay? So typically people are going to want to respond. Here's our NOD here, notice of defense. You fill that in, you send it in. You can raise your affirmative defenses. You can note that there's insufficient facts, vague, ambiguous, request a hearing, these kinds of things. But you don't want to get that NOD in there, that notice of defense, raise your affirmative defenses if you have them, and so forth and so on. Now, from there, a question I get quite often is, well, can we settle the case without a hearing? Can we settle the case without a hearing? Because a hearing will be set down toward the end of my timeline here. So a hearing will be set. Yes, the answer is yes. You can certainly seek to settle. You can certainly seek to settle. Let's star that because everybody likes that one. You can seek to settle. The regulatory agencies have wide latitude on what they want to do to settle. If they want to settle, they don't have to settle. They may force you to a hearing. That's something that you're going to have good counsel in there negotiating, trying to get a deal done. Okay, so you have a settlement period where you're seeking to settle. You can also settle before, and like a pre-hearing settlement conference, another opportunity to settle. The court may set that, or you could file a motion to set the hearing, but there's another chance there if you can't get it done. And finally, really the only other main point to talk about here is discovery. Yes, we can get a copy of any materials that they're using to deny you. We can request to know who their witnesses are. We can get the file, any documents they plan on using at hearing. This is part of the discovery process. Just like a civil suit, you can exchange information so that you're ready for a hearing, okay? We don't do trial by ambush, so it's a chance to get the documents. Subpoena power is available. You can also potentially petition for a deposition. So if you have somebody that's absolutely relevant to the case, you absolutely need to subpoena them get a deposition in. You can petition the court for a deposition. And by the way, these cases are not heard in a court of law. They're heard in what's called the OAH, the Office of Administrative Hearings. Okay, this is where they hear your cases. It's in front of a neutral administrative law judge who makes the decision. Okay, affidavits are also part of it. Be thinking if you're in these cases, if you have somebody that just can't testify, won't show up to testify, unable, they can submit an affidavit sworn under the penalty of perjury. That's something that can be used as evidence in a hearing. You have to give the regulatory agency and their counsel, you have to give them a chance to object and request cross-examination. Okay, so affidavits are possible. If discovery is not forthcoming, you always have the motion to compel possibility, just like a civil court. Motion to compel possibility. Okay, the pre-hearing settlement conference, we talked about that. Hearing. Okay, so if you can't get it settled, you're not getting the type of settlement you want, hearing is possible. Again, it's in front of the Office of Administrative Hearings, the OAH. It's in front of administrative law judge. You come in, you plead your case. The other attorney for the agency will be there, likely opposing you, okay, likely throwing everything they have against you. So it's important, if you want to get counsel to help you prepare your case so you're ready for that, be thinking about that, okay? After the hearing, there's usually within 30 days, you're going to get a proposed decision from the administrative law judge. This can be a proposed order, and the judge is going to say, this is what I think should happen. I think the license should grant. I think there should maybe be a restricted period, whatever. Who cares? But, I mean, we care, but it's going to be a proposed decision with some findings of fact. In other words, this is what I found. This is what the evidence showed. This is what it is. And so that then goes to, now that's not the final decision, that goes to the commissioner's office, okay, and then the commissioner is going to have the final say. So the commissioner can either accept the decision, modify, alter it, change it. The commissioner holds the cards. That's the important thing to keep in mind. The commissioner holds the cards. That's why it's important here to try to work out a deal, because you know at the end of the day they're going to hold the cards. Now, the conventional wisdom would be that the commissioner would usually defer to the findings of the judge, because the judge put in their time, he or her sat there, listened to all the evidence. So there's a strong possibility, I should say, that they would defer to the judgment of the judge, but the commissioner does hold the cards. It's important to realize that. If that doesn't go well, you have a motion for reconsideration to the regulatory agency. Please reconsider. There's a couple things that weren't heard. Have we thought about this? And we'd be willing to do that. So there's a chance for a reconsideration period. And finally, if all else fails, if you're not getting your license, something's unfair in the process, especially if you have some due process violations, then you may want to reserve the right to do a judicial review. That's going to civil court in what's known as a writ of mandamus, okay, a writ of mandamus. So, and we'll talk about that in other videos, but that's it. I mean, this is basically your statement of issues process. If you need an attorney to help you in this process, more information is provided on our website, statementofissues.com, statementofissues.com. That'll take you right to our page, okay? So Attorney Steve Vonner, we've helped lots of other real estate brokers. If you need some help in a real estate matter with an agency, a licensing board, investigation, subpoena response, complaints, litigation, arbitration, give us a call. We're happy to help. We offer low, flat rate fees in many of our cases. Okay, we thank you for watching this video. Make sure you click that red V for victory and subscribe. Make sure you subscribe to our legal channel. We appreciate you following us, and feel free to share this video on your social media networks. We'll see you again. Take care.